Before we turn to our third panel, just as a reminder, for CLE credit, there will be a code read during the panel. Please listen out for that code, and then we will try to repeat it near the end of the panel as well. I will introduce our moderator for the third panel on trials, witnesses, and juries. And as Judge Rosenthal indicated, these topics necessarily blend together. So some of what this panel will discuss, I think, has been foreshadowed by some of the observations in the first and second panels. Our moderator is the incomparable Sheila Birnbaum, who is a partner at Dechert. She is a giant of the defense bar and has been the lead attorney or otherwise deeply involved in some of the major mass tort and other complex litigations in recent times. She was previously a partner at Quinn Emanuel and at Skadden Arps. And for those of us here at NYU, she is a graduate and also a former faculty member of the law school, and has been a great friend to the law school and to the center. So without any further ado, I will ask you, Sheila, to get our panel going.
Thank you, Troy. We have a terrific panel today. I thank all the panelists who are giving their time so freely on these topics that I think are of great importance to the audience and all of us. So let me introduce, and cannot do justice to any of them, so I'm going to make these introductions fairly brief. I'm going to start with Judge Lee, who's a judge for the Alameda County Superior Court in California, a graduate of Columbia Law School. So she's on both bi-coastal and will give us a perspective of the trial judge on some of these issues we're going to be discussing. My good friend, Judge Rothstein, who has had many roles, but right now is a judge of the U.S. District Court for the Western District of Washington, was a state court judge before that. She's a graduate of Harvard Law School and has been very involved in the federal courts and is going to give us a deal of thought about what's happening in Zoom trials and other issues from a federal court perspective. We're also very fortunate to have two of the best trial lawyers in the United States. They're not on the same coast, but they should get to know each other if they hadn't. Mark Lanier is the founder of Lanier Law Firm. He's one of the best known plaintiffs lawyers in the United States, trial lawyers, and we're very lucky to have him and his insights. He keeps us defendants on our toes. And last, but certainly not least, is Ben Rubinowitz, a managing partner in Gair, and Conason. It's much longer name, but we're not going to get into all the others. He's a great trial lawyer. I've seen him. He's a mainstay of the New York Plaintiffs Bar, and we're very fortunate to have all the varied perspectives we're going to have today. So what we thought we'd do is sort of do this in a question and answer mode, so we could have a lot of interaction with this group and get everybody's insights into some of the more important issues that are confronting the courts today. So let me just start out by asking a question about, we know Zoom trials are going on. Are they better or worse than regular trials? And also, while you're doing that, especially from the judges, would you order Zoom trials if the parties are not are objecting to it, if any party objects to it? So why don't we start with the judges, and then we can get, I know Mark and Ben have very strong feelings on this as well. So, Judge, which one of you want to start? Just jump in.
Judge Lee, I'll let you go first if you want.
Sure. So there's a number of questions that have been raised with respect to Zoom trials. You know, in Alameda County here in California, we've been proceeding with Zoom trials in both in civil matters. And I really only can talk about civil cases. On the criminal side, we are in person. To the extent that we have in custody defendants and they are demanding in-person trials, those are going forward with various protocols. But I don't do criminal cases, I only do civil. On the civil side, we are proceeding with Zoom trials during COVID. In cases where there are preferential trial settings, 5-year statutes, and other cases where they must go forward. And the parties are on one side or the other is requesting and demanding that they go forward. And so we are going forward with those. So the question is, you know, the pros and cons, I guess, with respect to Zoom trials. There are a lot, and it depends on your perspective, right? So we have the perspective from the jurors, we have the perspective from the court, and then we have the perspective from the lawyers. And to some degree, they may overlap, but other times there are quite different perspectives with respect to whether they are same or better or not with respect to Zoom trials. Number one, it is in my court, at least, and in our courts, we do not proceed with a remote trial if one of the parties objects. Let's strike that. Except in a COVID situation. All right. If a party would object, we would be inclined not to do it. However, that is not true when we are in the COVID situation, because we believe that these certain parties have a right to have that trial go forward, particularly where we have a plaintiff who may be who is at risk of dying within 6 months, and so those cases are going forward in a Zoom case. And to the extent they've been challenged, we have rejected those challenges. They've gone up to the Court of Appeals on writs, and the writs have been pretty much summarily rejected in that regard. But COVID is a very special situation, although I would say, even post-COVID, there may be situations where we would end up going forward with a trial and doing it remotely. And I just got something from the National Judicial College about those situations where courts may be closed up and inaccessible, physically inaccessible, because of protests and riots and so forth, that we are quite concerned about in the future. So so the question is when we go forward with the Zoom trial, is it a pro or con? In my view, from the juror standpoint, and I've done one to verdict. It was a defense verdict, by the way, and it was the defendants who were protesting this Zoom trial, but they ended up getting the verdict in their favor. And I've also we've gotten in our court, we've done at least I'd say 2 verdicts. Some have started and then have settled in the interim, but we've gone forward with it. From the juror's standpoint, as a general rule, they actually have been very happy with Zoom trials because of its convenience. So we have a very large county, and to travel from one part of the county to downtown where the courtroom may be, it has always been a difficult situation with the traffic and so forth, going through security, et cetera, et cetera. And so from their standpoint, they've been very pleased with having to be able to appear remotely and not have to worry about that situation, as well as for those who may have other obligations that would make it very difficult for them to appear in court at 8 o'clock in the morning and having to go home by 6:30 or something of that nature. So that's the from the group standpoint. But they also have indicated to those who have done jury trials before and been in a jury that they did miss the interaction that they would have with other jurors and getting to know other jurors during the process of the trial. So they did miss that. And some of them at the time of deliberations, their preference was to actually appear in person to do deliberations. From the court standpoint, we've been pretty happy with being able to go forward with the Zoom cases. We have to grant many less hardships for the various reasons I talked about in terms of jurors' convenience and abilities to get to court physically. We think that jurors are able to see exhibits much clearer on a screen than they would in sitting in the courtroom. And they also can see witnesses right up front. And there's not been an issue. And so I like that. And I think that they can both see and hear actually witnesses and lawyers both much better. But from the con standpoint, from our point of view as a court, it requires many more court resources. So there is a question of whether or not we would want to ever go forward in any regular basis with Zoom trials, because it is a huge demand on court resources. We have to have jurors, we have to have people in court, not just our court clerk, who's attending to normal things as you do in a trial. We have to have somebody who's looking at the jurors all of the time to make sure they don't drop off. Because if you drop off and we have to break when they come back on again, when everybody's back on again, I have to have, and I've done this, had the court reporter reread those portions that juror may have missed, or lawyer. So we need a lot of, it's a very, from a court resource standpoint, very intensive. And right now, actually, we don't have all of the resources we need for that. And even if we were full up with all of our court support staff available, I think it is it requires a lot of resources from our standpoint. And also, we are concerned about jurors who are unable to appear because of their inability to have access to electronic means, or they do have access, but it's being utilized by other persons in their household. In that regard, we've worked around that to a large degree. We supplied laptops. If you can supply laptops to your jurors that have internal hotspots and only have the case on it, that solve a lot of those problems. So there are ways of getting around it, but there certainly are cons sort of with that situation. And then just the various things that lawyers will tell you about with respect to why they may not be in favor of Zoom trials because of some of the practical standpoints of using the computers and so forth, internet service, et cetera. And Zoom fatigue, which I think one of our lawyers will talk about. But as a result of the fact that we know that actually, even before COVID, I only did half-day trials. I only went from 8:30 to 1:30, no lunch, 2 breaks. And the reason is because it just was much more efficient from my standpoint. And I have calendars in the afternoon that I have to take care of. In a Zoom trial, I do not think we could do it all day. I just don't think that jurors can really stay on a screen for a full day of testimony. I think you have to reduce the amount of time that you have on screen for your jury trial. So it means it's a longer trial, right? It's a longer trial. So from those standpoints, that's sort of where I stand. And I will leave it up to the lawyers to talk about what they believe are the pros and cons.
I'm sure the lawyers are going to have a lot to say about it. Before we get to them, we've covered so many of the topics that we're going to get into in a little more detail. Judge Rothstein, you want to comment on your view of these kinds of trials?
Right, but again, because I think we need to hear from the attorneys, I'm going to just touch on the more general aspects of it, maybe set the table for them. There's no question in my mind that a Zoom trial cannot compete with the real thing. I mean, there's nothing like being in a courtroom. There's nothing like the lawyers being able to see the jurors and the jurors being able to see the witnesses and all. But the fact of the matter remains that we have encountered something the likes of which we've never seen before. And the big question was, how can the courts handle this? I mean, do we just shut down completely and not have civil cases for another year or so? I mean, we're talking, some of us are talking about getting the vaccines in April or May or June. And that would mean that we have held trials up for going on almost 2 years. And so what has happened is people are looking for ways that can meet the requirements of a fair trial, though it may not be optimum. And I think the remote jury trial meets those minimum requirements. So I'm not for a minute recommending that we stay with it any longer than we absolutely have to. But I think experience has shown from not only Judge Lee, but other judges who have tried it, that jurors like it. They can be relied on to pay attention, even though they're sitting alone in their own homes. That we can find ways to provide them with the adequate means. Our court makes laptops available to the jurors. We send them out. We send them out to them if they don't have their own. I think the real issue that people were afraid of was how representative would the jury pool be if we were limiting it to people who only knew how to work a laptop or an iPad. And surprisingly enough, or maybe it's only surprising to somebody of my generation, but there are an awful lot of people out there who find themselves quite facile with these items. They're able to use them. We, of course, as Judge Lee said, it's very, very dependent on the quality of the IT staff that the court has. We've been very fortunate because the court has been so heavy in IT that we have wonderful people who can help us, help the judges, help the jurors, help the attorneys. I'm going to save some of my remarks till I'm answering or confirming or denying whatever the attorneys find as pluses or minuses. So I think I'll wait.
That's
Sheila?
great. Yeah, that's terrific. No, I appreciate that. Mark, do you want to start? I know someone who loves looking the jury in the face. This is a very difficult situation.
It is, and it's an honor to get to be here, by the way, with such austere company. Thank you, Your Honors, for giving the time to not only do your jobs, but to do this to enhance our practice. And of course, Sheila, you're an icon to me and so many others. Thank you for allowing me to be on this panel. And Ben, I hope you don't have to spend all your company with the like of my ilk. But having said all of that, I think it was in Plato's Republic, which is one of my favorite books for government, period, where he wrote, "Our need will be the real creator." And we have a similar saying in English that necessity is the mother of invention. And I know that there is a driving, compelling need right now to do these types of trials. And I recognize that. And I think these trials can be done in a way where justice is met. Having said that, everything's got pluses and minuses. And those have been listed to some detail, but what I like to do is group the minuses into three buckets. The first bucket is kind of a bucket of limited vision. So for example, right now I'm talking on this. I'm staring directly into the camera, which means that you're able to see me looking at you as opposed to me looking at the different people who are on this monitor when you don't see me looking at you. So I have a choice between trying to make eye contact with you or make eye contact with you watching, and then I'm not making eye contact with you. It's one of the inherent difficulties when our vision, our field of vision is by definition limited. And we don't have the benefit of peripheral vision so readily, where we're able to perceive things like someone can in trial. Now that's true of me as a lawyer. When I'm trying a case by Zoom, I can have a choice. I can look at the witness, I can look at the jurors, or I can watch the witness and watch the jurors, but I cannot do both. And so this limited vision for me as a lawyer makes it more difficult for me to be as compelling and persuasive. I'll go a step further and say the same difficulty is there in a sense for a witness. How is a witness to look at me if I put a document on a display, look at the document, look at the jurors, and yet try to facilitate everything else? That limit of vision makes it tougher to be a lawyer, a witness, and I dare say even a juror, because there are times where jurors will want to see the reaction of someone else in the courtroom that may not be on a camera, as they're gauging the atmospherics of what are going on, not simply the words of what are being said. And so this limited vision is one bucket. A second bucket that is a minus bucket when we Zoom trial is the change in atmospherics. What do I mean by that? Well, we care about the atmosphere of a trial because it enhances the gravity of what we're about. It enhances the need to focus. It enhances the moment of integrity. And so we have courtrooms that are designed with atmospherics in mind. The judge sits up on a dais higher than everyone else to show the elevated platform of the law. The jury boxes generally are higher than the well to show the elevated role of the jurors finding the facts. Those dynamics of atmosphere that are in place in courtrooms are gone on the internet. And all of the benefits of that atmosphere are gone on the internet. The atmospherics of dress. I've got on a suit coat. I have on a spiffy tie by my definition, and I have on a white shirt because on TV, a bright shirt, a white tie, and a dark jacket seem to come across better. But I got to tell you, I'm wearing jeans from here down, and Judge Rothstein would not let me, and Judge Lee would not let me do that in their courtroom. But does it make an atmospheric difference? I dare say it does. I won't even show you the socks and shoes I have on right now. But how we dress, judges wearing judicial robes, knock, 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 oh yay, all rise. All of that has atmospheric gravitas that lends to the seriousness of what we're about. Justice, we have courthouses. I tried a case in a courthouse, federal court in Newark, New Jersey, where you've got these huge sculptures out front of blindfolded justice. And all of these things we've spent so much money to establish great atmosphere are lost in the world of Zoom. And then the third bucket is just the interaction bucket of jurors getting the benefit and lawyers getting the benefit and the judge getting the benefit of seeing how people are interacting with each other. And that's something that gets lost in the Zoom world as well. So those are the minuses from my perspective, but I don't want anyone to think that means if I'm in a Zoom trial and it goes up on appeal, someone's going to cite this and say, Lanier didn't think this was a legit trial. You can't get to justice in a Zoom trial. And as these judges have already said, but I just remember our need will be the real creator. And I hope one day our need will return to us a face-to-face trial.
You can see that Mark would have no problem keeping the attention of the jurors in a Zoom trial. Ben, and then we're going to get down to specific questions after you finish and try to hone in on some of the real issues. Go, Ben.
Well, thank you so much. And thank you for allowing me to be part of this series. And Sheila, it's always a pleasure to work with you. We've been working with you for many, many years. And I know my partners and I have the greatest respect for you. So thank you for inviting us.
I don't see Sheila in your contacts. Who do you want to send it to?
Oh my gosh. At any rate, I do also want to say this with Judge Rothstein. I happen to agree with what you've said. And that is, I hope that we get back to regular trials sooner rather than later. And in picking up on what Mark said just a moment ago, I think that there's a way of looking at it, and that is the majesty of the courtroom truly has some real meaning for all of us as trial lawyers. But if we're going to take a look at that and the majesty of the courtroom, the question is why? Why does it have such majesty? Why is it so important? And why does it command that type of respect? And the answer is because in the first instance, we truly do have a cross-section of our community as jurors. But with this type of experiment that we're doing right now, working with Zoom trials, do we really have the same jurors available? Do we have, for example, the minorities? Do we have those that are coming in, for example, that don't have the ability to even have the privacy of a room where they can actually watch the trial without being bothered or without being interrupted?
I don't see Sheila in your contacts.
Excuse
Who
me,
do
I
you want to
apologize
send
for
it
that.
to?
But the question that I have is, why in the world, just like this, for example, an interruption like that, I think it's actually a perfect source, and I didn't even plan that, but that's what I'm talking about. Look what happens. There's an interruption, unfortunately, because of something like this. When we take a look at who are the jurors, age, for example, do the jurors who are older, do they have the same facility with computers? I recognize that Judge Lee has said, for example, that they hand out computers to the jurors. In New York, I can tell you, they have just basically done away with 45 to 50 jurists, the judges themselves, because we don't have the funds to do this. How in the world are we going to be able to hand them computers to work with? So one of the things that I focus on first, before we even talk about the logistics and the jury itself, if you don't have a fair jury, you're not going to get a fair shake. We've been doing this for 150 years. We have to wait another few months until the vaccines come out. I'm okay with it. I do think that there is a place for Zoom presentations and remote access.
I don't see Sheila in your contacts.
And certainly
Who
that
do you want to
is,
send it to?
certainly that is with respect to the conferences that we have in court. Certainly that is with respect to mediations that we might have. But as far as the trial itself, the answer that I have is no, I am very much opposed to Zoom trials. I don't think we get a fair shake. And when we speak about cross-examination or the examination of witnesses and doing demonstrations.
Hold on to that, Ben. That's going to be my next question.
Okay.
So hold off and let's just set the table, because I think let's just assume, for the purposes of the rest of this program, that we're having a Zoom trial. And how do we make it as good as we can make it in order to...
Who do you want to send it to?
Is that you, Ben?
I don't know if it's me or somebody else, but I'm going to try and check.
Okay.
No problem.
If you go on mute, if you're not speaking, I think that helps a lot. Let's assume that we have a Zoom trial and we want to make it as good as we can. What are the points that we need to explore, and how is it working, and how can we make it better? So let's start with witnesses and cross-examination and documents that one would use, because usually with witnesses, you're going to be using documents as well. Mark, if you want to start with you, do you have any thoughts on when you're dealing with a witness and you're cross-examining and you can't do what you would do in the courtroom, how you would do it to get the most out of your examination?
Okay, I do. I've thought a lot about this, and I'll try to say it in two sentences. First of all, anybody who needs to email me for this or email NYU, I'm glad to provide it, but we've developed a protocol that we've used with Rule 43 testimony that we've taken live via internet, beaming across the skies, whatever it is. That Rule 43 is very akin to a Zoom trial, but there's a protocol that needs to be in place, because anytime you're taking a witness, especially cross-examining a witness via an internet or a Zoom app medium, you need to make sure that there are rules in place about that witness. Who do they have in the room with them? In other words, if I'm going to cross-examine Sheila Birnbaum's witness, I want to make sure that witness is not allowed to have someone in the room on the other side of the computer that's nodding answers to the questions. I want to make sure that that witness has got one representative for each of the parties in the room with the witness, so that those formalities are taken care of and you don't have any worry about that. And I'd love to say, oh, witnesses would never do that. We just tell the lawyers, don't let the witness do it. Balderdash, malarkey, whatever the word of the year is. No, I don't accept that. I have a responsibility to make sure, because I've got at least 3 times where judges, federal judges, good, solid federal judges have stopped a trial because they wanted to refer the witness to the U.S. attorney for perjury. This is not something that I take lightly. I think we've got to have these procedures in place. So there are a lot of procedures like that. Similarly, if I've got cross-examination documents, do I need to give those documents to the witness and their lawyers a day or two ahead of time and say, hey, I'm going to quiz you on these. Why don't you take the next 48 hours and get yourself refreshed on them so that you've got good, pat answers down? No, but yet you've got to get the documents there and make it as real as possible, but still leave room for the vivacity of a live cross-examination. So that's one set of concerns that I've got is that we do that in that way. The other set is I've tried a lot of cases that are really complicated cases. And one of the great challenges, but joys for me as a lawyer, is getting to explain to a jury a complicated concept in some way that the jury readily not only grasps it, but is able to use it in their brain to work through the trial. And oftentimes that for me has worked most easily with demonstratives, where I've used a demonstrative. So I can remember trying to deal with a witness who was saying, we tested product A, but we sold product B. But product A and product B are really not different. So that we tested product A, but sold product B should not be a problem. And the best way I could illustrate the difference is to give that witness a box of donuts in front of the jury that were made by Dunkin' Donuts. And then ask that witness to do a taste test between those donuts and the donuts that I was holding made by Shipley's, a local donut maker that everybody on the jury loved. Well, the witness properly said, I can't compare the two if I don't taste the two. And I said, but wait, they have the same ingredients. Read the ingredients on your box. I'll read the ingredients on my box. Well, I still can't compare them. I said, but yet you're willing to sell product B because you say it's the same as product A because they have the same ingredient. You know, that type of stuff, you just can't do that in a Zoom trial. Here, let me hand you these donuts through the camera. Doesn't work. And so it limits somewhat what you're going to do with witnesses as well. That's okay, but let's recognize that it does.
It limits your shtick. That's what it limits, Mark. And now you have to do it for real. Don't respond.
No donuts. No donuts, Mark.
Judge Rothstein, you want to comment on that? And Judge Lee, and then we'll go to Ben on witnesses.
There is no doubt, and I think I've mentioned this before, that a long time ago, having been a trial lawyer, that I recognize that a good portion of, in addition to being skilled in oratory and the law, a lot of being a trial lawyer depends on theatrics. And theatrics are a wonderful part of playing before a jury. One has to come back with a weighing, you're weighing two things. You know, you're weighing whether you're going to get the trial that you're used to, maybe the perfect trial as far as you're concerned, against the fact that there are some people who will not get to trial at all for a number of years. And it's not just when we get that vaccine around, it's also the fact that if one were not to have remote jury trials, then such time as we're all ready to go back to trial, you're going to have a backup of cases that will go on for months. So the first case you try is the 3-year-old case. And then, you know, by the time you get current at the rate that courts go, I mean, you have trials that are going on for 3, 4, 5 years. People die. People who need the money because they had something done to them. I mean, where is the justice in keeping it going? And if it means, Mark, disposing with the donuts and maybe trying it with a little less than you would like to do. I come back to the fact, you know, life involves a lot of balancing, and I do not claim that, and I don't think any judge would, that a remote trial will ever replace courtroom. The drama of a courtroom, the reason we build them the way they do, the reason we make them look magisterial is because we want people to think of the law that way. I mean, it's the backbone of our country, and we want respect, and we want people to recognize how important the law is. To say that we will go without that is a very, very serious step. There's no question about it. But it can be done. I mean, I've tried, Kate, long before we had this problem, I've tried cases where we've had witnesses coming in just by deposition, remote deposition, and we've had them shown exhibits, and those exhibits have gone to the jury, and the jury's managed to see them. And instead of seeing them all at once, like 8 of them together, they're seeing them separately. And there are ways of, I mean, some of this has already been done. Some of this is not brand new. The fact that we're having the jury out of the courtroom, that's the part that I think is troubling you, and I can understand that. I just think we can make do, that they still will see the exhibits. Some of them will see those witnesses better than if we tried to put them behind masks. I mean, they're not going to see much of a witness without a mask. I think you can see a lot about a person. Well, I'm going to let Ben Hyde jump in here or whatever.
Judge Lee and then Ben. Go on. You're on mute, Judge. Judge, you're on mute. There you are.
Thank you. But number one, by the way, I'm being brought back to New York with words like shtick and so forth. You know? So thank you. But you know, here's the point, which is in the COVID situation, which is what our other judge was talking about. We don't have terribly much choice if we want to go forward. And by the way, unless there's a trial, we don't get settlements, right? Cases don't settle. We need trial dates, as everybody knows. But so post-COVID or post-emergency or other of that nature, I'd say we are not going to do Zoom trials. We are going to be in person as we would normally do, because that is our preference. It's our preference for a number of reasons. There are a number of types of cases, though, unlike the ones probably that Mark and Ben tried, that actually are amenable to Zoom trials. Court trials, for instance, small claims, all kinds of other proceedings, protective orders. You may want to do those remotely for various reasons, but absent that, when we're talking about complex cases, significant tort cases, lengthy cases, asbestos cases like I have, our preference from the court standpoint is to do them in person. Absolutely, there's no question. But we don't have that choice in situations like COVID or similar situations. And in that regard, there are some positives to doing a Zoom trial over an in-person trial. And I think we touched upon that. In person, which we do in criminal cases, people are in masks, they're behind plexiglass, they are socially distanced, very difficult to see and hear witnesses, hard for the court reporter, and people have been getting COVID. And then we have to stop, or we have a mistrial. So there are a lot of negatives about having in-person cases during a COVID type situation. But yes, I would. I love to have lawyers such as Mr. Lanier in court. You know, I enjoy that, and I think the jurors do as well.
Dealing with the lesser of the evils, for sure. Ben, I know you have some very strong opinions on cross-examination, and maybe you could tell us. I assume neither of you have had a Zoom trial yet. Is that true, Mark?
That is correct.
Okay, Ben, go ahead.
So let me first address what Judge Rothstein says. I think the comment is very important, and that is what happens when you're dealing with a client, for example, who is an extremist, where your client, for example, in the cases that I have, someone who's suffering from a cancer or breast cancer might be dying. We have videotaped that testimony, and we have played it later on at the trial in front of a jury. Why have we done that? Of course, for necessity. And that's something that actually does work in camera very well. But with respect to the cross-examination itself, the fear that I have as a trial lawyer is that if I'm cross-examining a witness and somehow the feed goes out, the bandwidth goes out, and we get stopped so that we all of a sudden cannot hear the witness, or the jurors can't hear what's being said, you break the flow of what's going on during the cross-examination itself, and you interrupt the trial. Whether or not you can ever get back into the same flow that you had is quite a story. If it works, great. If it doesn't, you've hurt your client terribly. So I am concerned about things like this. With respect to a bench trial, certainly I agree. Let's move forward with the bench trials. I have no problem with that at all. But I am concerned about the ability to actually cross-examine the way that we've done it in the past, where the jurors actually feel what's going on. They see the witness. They can assess credibility in a way where they can actually examine what's happening in the courtroom. You can see what's taking place between the witness, for example, and the defense attorney or the plaintiff's attorney. Or they can assess, for example, the plaintiff as the plaintiff himself or herself walked into the courtroom. And they could see things that you can't see when you're just showing, for example, the limitations of a head on a screen. So I think that there are some real concerns that we have in cross-examining a witness. And I do think that although time is of the essence in certain cases, there are cases where it might be better off to actually videotape a certain portion if you have to, and proceed with the in-court trial. Once again, we maintain the majesty of the courtroom, which says specifically respect. And that's really what we're looking for, to make sure that the jurors aren't interrupted, that the witness isn't interrupted, and certainly that the attorney is not interrupted in the flow.
Sheila,
Mark, I know you want to comment, go ahead, and then I'm going to tell this audience what the code is, so don't let me not do that, because that's
Okay.
important too.
I'll
Go
do
ahead,
this
Mark.
quickly. I'll do this quickly. First of all, I'll say I was so anti-Zoom trial until we had our prep session for this. And the two judges on this session talking through it changed my mind and caused me to readdress some things. That's why I'm a little bit different place than I was when we prepped. But I'll add this as well, and this is what I really want to underscore because several comments and questions have been typed in that this addresses. The concerns that I have, the concerns that Ben has, the concerns even expressed by the judges. The reason it's okay and it works in a Zoom trial anyway is because every limitation I've got, the other side has too. Every problem I've got, the other side has too. So it's a level playing field, which is ultimately what a court's called to be. We just have a narrower playing field. We have some handcuffs on us while we're playing, but both sides are equally handcuffed. I'll shut up now. Thank you.
It's not necessary at all. Then just let me give you the code and I'll read it slowly. CCJCC34. Once again, CCJCC34. And we'll do it again at another point. Let's move on to juries. We've been talking around the juries. Are we really getting a true cross-section of eligible jurors? Do jurors have sufficient equipment? I think the judges have said that in their courts, they're giving out computers for some jurors. Judge Rothstein, Judge Lee, you've seen Judge Lee, especially the Zoom jury trial. Do you think the jurors are paying attention? Is there things we need to do? Are there lessons learned that you can share with us with regard to the juries? And also, I know you talked about special instructions that you give to jurors, especially in these kinds of situations. So I would love to hear from you.
So maybe I'll step in first because I have actually done a few of these. So there are three parts of the trial that you have to think about when you're talking about jurors. Jury selection process, the trial itself, and then jury deliberations. And actually, and from my standpoint, in terms of the Zoom trial, they present different challenges and different issues that you have to deal with as the court and as lawyers in that regard. So from the, let's see, I guess the question is with respect to how we proceed with with each of those stages of the trial. We are trying, we have kind of a hybrid system with respect to jury selection, and then later on with respect to jury deliberations, because they require different protocols. I have found that, at least from the jury selection standpoint, we're trying to do them totally remote at this point, where jurors don't ever have to appear in court unless they need to, because they don't have access to electronic means. Where we are providing hardship questionnaires, we're providing case-specific questionnaires, which can be lengthy, as Mr. Lanier knows, particularly in the asbestos cases, and so forth. All doing that all remotely. We have found that I actually, my personal view is that I get a better cross-section of the community on a Zoom trial, particularly during the COVID crisis, because our maybe it's California, I don't know, but we have very few folks who are not able to have access to some electronic communication, internet services, or are unable to do so. Almost everybody has a smartphone. You can get on Zoom on a smartphone. You can get on Bluetooth on a smartphone, and so forth. So we've had very few issues in regards to access. And as a result of that, we get a better cross section. We get older people who would be afraid to come into court, who would be really hesitant to do so, or would have, access problems. We had a juror in my trial that went to verdict. At one point during the trial, a juror had to go to LA. He brought his laptop with him. He was able to continue to be a juror in the case. So we had young people, older people. I just thought we had a better cross section of the community participating in the case. And then of course we supplied laptops to all the jurors. They had to use the laptop that we provided. They didn't use their own electronic communication. They didn't use their own computers. But that being said, it is really important, and one has to emphasize throughout the trial, to remind the jurors that they are to conduct themselves as if they were in court. And that becomes really important. And it has been an issue in other cases. I didn't find it particularly in mine, although maybe some of the lawyers might differ in that regard, but you do have to remind jurors that they are to conduct themselves as if they were in court. And it really becomes later important for the jury deliberation process. That there shouldn't be other people in the room, that you're not to have you don't take care of your pets while you're listening to the testimony or deliberating with other jurors, particularly when you're deliberating, that you are totally by yourself and nobody overhears what's going on, and so forth. So that admonition has to be repeated, I think, often, and reminded. And then, as we watch our jurors, and we have to watch them carefully throughout the trial, that people are not disappearing and going off and doing something, or looking at other computers. We don't know for sure, but that's we do need to do that. So I think I'll pass it on to others at this point.
I think that, Ben, why don't we go to you this time? And I know you have some strong views about the jurors, but how would you avoid juror fatigue and keep the juries involved and interested? Do you have any thoughts on that as well?
I think one of the,
No, for Ben.
Oh, for Ben.
Yeah.
Okay, so let me just say, just to back up for just one moment, what Judge Lee just said as far as watching the jurors and making sure that they're not interrupted by giving them that instruction, I think that's terribly important. But I also think it's important to answer your question directly, Sheila. It's up to the lawyers to try and emphasize things as best as we can during the remote session. I suppose it's a little bit more difficult where we can actually map things out in a courtroom where we're trying to do, for example, an in-court demonstration. On the other hand, I happen to agree with Mark to this extent. If we're going to be doing a Zoom trial or a Zoom presentation, yes, we have to find a way to actually make those exhibits come alive or make the demonstration come alive. It's one of the things that we work with at the National Institute for Trial Advocacy all the time. So I suppose there are ways to try and keep the jurors' interest going. I wonder how difficult it will be, though, to watch the jurors as we would while we're trying a case. And I wonder if we'll be able to do the same, to actually see that they are paying attention, or that they do have a quizzical look on their face when we're asking a question, or to reemphasize a certain point when we know they haven't gotten it. So I think that these are the challenges that we have. And I agree with what Judge Lee said. Certainly, if we're watching the jurors carefully, we can make sure that they are paying attention.
Judge Rothstein?
Oh, let me make a few comments. In response to what Ben said, you can't watch the jurors on Zoom while you're doing the trial. You would need to have somebody else doing that. Doesn't have to be a lawyer. You know, I'm going to say it's high-priced talent to have somebody sitting there watching jurors for 5 hours a day. Doesn't have to be a lawyer. It just has to be somebody who can say to you, you're not getting there, you know, or this juror has a question, or they didn't understand that. But there are ways that we can anticipate some of this. And I think Judge Lee hit some of them. One is to keep instructing the jurors, to emphasize to them how important the case is and how important their role in the case is, and how we're relying on them to listen. The other you have going for you is these people are home, and many of them have nothing else to do. And, you know, I know people who would be happy to sit on a juror just to take up the time and day when they're not going to work and they're home. Now there are some that have, you want to make sure you don't get somebody who has little kids running through the room, you know, during the time you have your important witness on the stand. This is a matter of being very careful with jury instructions and being careful in voir dire. But my experience, or the experience of the judges on my bench, have been that you get a broader panel of jurors, just what Judge Lee said. There are people who don't want to come downtown, like Los Angeles. Western District of Washington is a huge veneer, draws from a geographically large area. And there are people who don't want to spend the time driving. They don't really like coming into a big city. You get elderly people who find it very taxing to put in that kind of a driving time. You are, in a sense, expanding the jury pool that you're getting. And the other thing is that from the judges who have spoken to juries after these cases, the juries love them. They are not doing other things. They are concentrating very hard. They are excited about being on a jury, and they are enjoying the cases. They like the experience. They think the lawyers are doing a great job. That makes you guys feel better. They feel that they're understanding the cases. And one of the things, I do it in a regular court trial, and I would be more inclined to do it on a remote trial, is to let the jurors ask questions. And I don't mean verbally ask questions. I think heaven only knows what you're turning loose there. But to put it in writing and in some way work with your IT staff so that you can get those sent to you. So that if the jurors are puzzled about anything, I'm suggesting that as an answer to the fact that you can't see them enough. If you're trying the case, you can't be looking at them. Somebody has to be doing that for you. So you have to find a way to substitute for the fact that you're not seeing jurors' responses. And this is why I think if we're really going to do these remote trials frequently, there are skills that have to be developed, and there are sort of tricks of the trade that have to be developed to respond to the newness of the medium that we're using. And I think perhaps having the jurors email in the questions they have, if they're crazy questions, off the wall questions, we don't have to answer them. But if they're important questions that are showing you that you're not getting through to the jury, then we can correct. So, you know, I think I'm using that as an example of ways that we may have to devise means to correct. For instance, how do you handle a sidebar? You know, we know how to handle a sidebar now, but how are you going to handle a sidebar? You have to anticipate that and have the ability to go into a room at which only the attorneys and the judges or judge, only they are present, and the jury is out for that time. All I'm suggesting is that some of these flaws in the system can be dealt with if we are creative about it, talking about your need creates, new things. We may have to do that. Hopefully, we'll do it for a while and then forget it all. But if we're going to do these, I think I usually find that the attorneys are the ones who come up with some pretty good ideas to make the system work better. Hopefully that's what's going to happen.
Mark, do you want to comment on?
Yeah, I'll throw in a couple of things that occurred to me while we were talking. First of all, I absolutely agree with everything that's been said. I think it's insightful. There are certainly tools of the trade and mechanisms as a lawyer that I think will arise to the surface pretty quickly. I've already instructed my team. We've got a 16-foot wide by 9-foot tall, massive high definition TV screen or monitor screen that we use for major presentations and things like that in big forums. And I've told them, set it up, because I will have 4 people who are assigned to watch 3 jurors apiece during the entire process on the other side of my monitor, so that they can hold up for me whiteboards where they've written down, juror number 3 doesn't get this, juror number 7's laughing, juror number 8 has gone to sleep, whatever. And so that I've got that in real time in my peripheral vision while I'm talking. Those types of techniques and skills, there are some others as well that we're kind of chewing on right now about how to do. But ultimately, what we've got to be careful with here is we have, okay, I had a crim procedure professor in law school. So this is 38 years ago, who was an adjunct professor who came in to teach a class one day, having just tried a death penalty case. And he said the DA voir dired the jury and told the jury, voir dire is what we do in Texas, told the jury in voir dire that that the trial would not be like the jurors had seen on TV, that real trials are not like TV trials. And then he paused and he said, I will revoke your law degree if you ever stand up in a courtroom and say that. You have a jury who is trained to believe they know what a TV or what a lawsuit, a trial should look like because they've seen them on TV. If you make yours look like TV, you've got instant credibility with them. And I think all of these tools are things that are going to make us learn to try a case very much like you see on TV, so that the jurors who are watching it are like, yeah, man, this is like reruns of LA Law. This is Law and Order, man. I've seen this. This is for real. Because that's just another angle of how the furtive mind of us lawyers, as Judge Rothstein said, are going to sit there, like Judge Lee said, we're going to figure out how we can best do this. So it opens up big doors, and I don't want my whining about it to mislead anyone. But it's a brand new ball game.
Sheila, I have a question, if I may.
Yeah, go ahead. And I'll just make one comment, get to you, Ben. I must say that Mark has become a convert now of the Zoom trial. You should have seen him before when we first met. He hated every second of it. He just moves into it. Ben, go ahead.
So the question I have is for the judges, and I'm kind of wondering why, much like the restaurants in New York City, they've adapted. They've actually set up certain little kiosks where they can serve the food. Why can't we adjust our courtrooms, or we put up plexiglass, or we separate them, or we use, for example, the audience seats as the jury seats, where they can distance, but we can actually go back to trying a case in person in the courtroom and have some of the majesty of the courtroom be there for the trial. You're talking about costs the whole time, and I recognize that, and I actually appreciate and actually applaud your efforts in what you're doing to make sure that we do try and move the cases along. But what about actually setting up that with a plexiglass covering, or for example, changing the dynamics of the courtroom?
Ben, let me respond to that, because the courts have been doing that.
Mhm.
They not only have built-in plexiglass, around the judge, around the witnesses, behind where the lawyers would stand behind. They've also put in, I guess you'd call them snifters. They have changed the way the air in the courtroom, how many minutes between when it's changed and filtered. They've put in super filters. They've done massive things like that. And money has been, I won't say no object, it's always an object, but basically as little of an object as you can get, at least in the federal system. And they've gone to the biggest courtrooms. They've gone to the ceremonial courtrooms so that the jurists can sit 6 feet apart. They've done all of that, all the stuff that you're suggesting, and probably some that we're not thinking of right now. People have still gotten sick. Jurors go home. They go home. They have to get home somehow. They either have to get on a bus or a train or in their car, and they go home. And all you need is one juror or one court reporter or one courtroom deputy or one lawyer to come back and say, guess what? And then you've got a 14-day quarantine period, and what's happened to your case? Or you get jurors that are now so scared, they really will not come back to the courthouse. And it's happened over and over to many of the courts that have opened up and tried to do exactly what you're talking about. It's a vast staff that makes a courtroom run. It's not just two lawyers and a judge and 8 jurors or more jurors or what. You've got reporters, you've got all these witnesses, you got a witness coming in. Now you can test everybody. You still go home, you're going to test them every morning. And what if you test and get a positive test? Send everybody.
I think, Ben, one of the audience asked that question, and I'm glad you raised it, similar question. But I think as this is raging in some states, it's almost impossible. People are going to be locked down again. And if the bar doesn't get with it, they're not going to have trials, as Judge Rothstein said, maybe for another year. Hopefully it'll be sooner than that, but I think we have to adjust to the new reality if you want trials. Otherwise, the whole system is coming to a screeching halt. Let me just give you the number again for CLE credit. CCJ CC34. I'll repeat it. CCJ CC34. If we can do a very quick lightning round, we've run out of time. David, are we going to lose anything here, or Troy, you want to come back and tell us?
I think you can have another 8 minutes or so since you started 4 minutes late. Okay.
Well, why don't we do a lightning round? How's that? I always like lightning rounds. Why don't we go to each of you and anything you want to talk about that we haven't talked about? Each person gets about a minute to talk about jury trials in an era of Zoom. Why don't we start with you, Mark? Because I know you need no time to prepare.
So if we go back to the Declaration of Independence, among the 27 things that were enumerated that justified what some might call treason, the United States had grievances against the King of England. And those grievances were so great that they amounted to sufficient reason to declare ourselves independent. I think it was number 22 that said that King George had deprived our citizens of trial by jury. It is so fundamental to our system, and we don't teach that in civics anymore. Most kids can get out of high school without understanding that from a government class. And yet it gets reinforced when we do what we do, if we do it well. And so I commend the judges, I commend NYU, I commend my fellows of the bar, my sisters of the bar. I commend everyone who is trying to figure out how to make sure that this bedrock foundation of American society, a just society that will provide justice for all, as we say in our Pledge of Allegiance. I commend everybody on figuring out how to get that done in the midst of a plainly wackadoodle world right now. And so just my final 1 minute is applause for you guys. Let's keep justice going.
Judge Lee, as part of the justice system?
You know, I don't know how to respond at the end of that, but I think that there's something kind of interesting. I want to just give two anecdotes about what happened during this Zoom trial that may alert you to issues and also educate you in that regard. One is this question about the informality of a Zoom trial to some degree that is taken away when you're not in a courtroom, right? And there is a little bit of that, and you do have to be careful about it. I take questions from jurors, by the way. I do it at a certain point after witnesses, I mean, even in person, after witnesses testimony is completed, and before they leave the stand, I will ask jurors to submit any questions that they may have of the witness, and they're submitted in writing, and I have a sidebar with lawyers, and we decide whether we will ask the question or not. I do that in a Zoom case. We just go into a breakout room to discuss them, and we come back and so forth. But one of the things about that is you have to be careful, as you would in person, about jurors not making comments. We don't want to hear what they're thinking, right? We just want the question. And one of the things that happened in my last trial was, and we did it in Zoom, and they either did it through a chat to the court attendant or an email, and then they would submit it to me, and then I discuss it with the counsel. Is a witness, there was a PowerPoint. Now lawyers are using PowerPoints all the time. Actually, a PowerPoint on a Zoom case is actually more effective. It's right there. And in the PowerPoint, the expert witness had titled one screen as, it was an asbestos case, it was asbestos exposure does not cause peritoneal mesothelioma, something like that. And the witness was a witness who was testifying about experiments she had done with rats, and how they did not get mesothelioma, peritoneal mesothelioma after exposure. And the juror wrote back a little comment, emailed back a question. It was supposed to be in the form of a question, but it really wasn't a question, it was a comment, which is that he thought that the title of that screen was misleading because it wasn't that asbestos does not cause mesothelioma. It was asbestos does not cause mesothelioma in rats, right? He thought it was very misleading. So it was kind of interesting that juror was really, they were paying attention, and he was really paying attention to everything on that PowerPoint. So be really careful about how you use your exhibits, particularly in a Zoom case. And also, how do you handle those, those questions? You do have to have sidebars with your attorney, and you can do it on Zoom actually quite easily. The other anecdote I had was that we had not my case, in another trial. I don't know how this happened, but there was the attorneys and counsel, the counsel and the judge had to do a sidebar. They were put in a breakout room separate from the jury. While they were in the breakout room, the plaintiff apparently was on the stand, and they're just waiting for the judge and the lawyers to come back. And the jurors started chatting with the witness. And that should never have happened for a number of reasons, but we figured out ways to get around that now when the court has to use the virtual courtroom and go into a breakout room. But you do need to be careful. That was a major problem. They were talking about the witness's screen in the background, and it had nothing to do with the trial, but it was not good. So you do need to have those. You need to be alert to those. I just wanted to kind of give you those two little anecdotes about Zoom trials that were sort of unique to our case.
Thank you. Judge Rothstein?
Well, I'm awfully glad to see that Mark has moved from Plato to the Declaration of Independence. And I think that if this panel went on for another hour, who knows? We might even get more current. I think I don't really have much to add other than that the law, if anything, is resilient and creative. I've been out of law school long enough to remember discussing at great length what we did about signatures when people were unavailable. You know, I mean, signatures were, it took at least 3 different lectures to discuss. And when the mailbox rule, you remember the mailbox rule? You put something in the mailbox and you had to count 2 days or 3 days. And, you know, and I look back on all that. What, you know, none of us, we now are sending signatures back and forth with, you know, DocuSign and emails and all. The law is resilient. The law will recognize difficult situations and need to make changes. And that's what we're confronting here. The question is, how much of a change do we need to make? When we need to make it? When is it urgent enough? Like, which cases should we force into this new format? Which cases can wait? These are the decisions we're going to have to make. But the recognition has to be that there is a new format, and that at least in some urgent cases, we have to learn how to cope with it and how to use it so that we can still have a fair trial.
Thank you. Ben, we're going to give you the last word.
Well, thank you so much. And I suppose if I follow up on what was just said by Judge Rothstein, focusing on Mark going from Plato to the Declaration of Independence, I'll go slightly different. And there's a fellow by the name of Mick Jagger who wrote with Keith Richards, you can't always get what you want, but if you try sometimes, you might just get what you need. So I suppose we're trying to find a solution to a very difficult issue. And that difficult issue is how do we actually make sure that we get the justice that the clients are entitled to? And I suppose I applaud all of you for trying to find solutions to this terribly dangerous and deadly problem that we're faced with right now. And I suppose the concern and the fear that we have is, as trial lawyers, we don't want to go down a slippery slope where we never come back to the jury trial. So I'm delighted to have Judge Rothstein and Judge Lee say that, yes, we do want to return, and this is a temporary fix. And I think if we could work together to try and make it as good as we can, perhaps that's the right way to do things.
I want to thank you all on behalf of the Institute. Great panel, great thoughts. And as Judge Rothstein said, we're all very flexible. So we'll see you all at our next Zoom trial. And Troy, am I turning it back over to you?
Yes, thank you, Sheila. Thank you, everyone. That was a wonderful panel.